that old shed down. It's an eyesore on our lake.
That's what the HOA president screamed at her crew the morning I drove up the gravel road to my grandfather's lakefront land for the first time in 2 years. By the time I parked, a bobcat was already chewing through the cedar workshop my grandfather built in 1958, the same shed where he taught me to sand a cherry plank. I stepped out of my truck and just stood there, because behind that shed sat 14 brand new cabins, lined up along my shoreline like she owned the entire county. She turned, smiled, and told me I was trespassing on a private community development. A community development sitting on land my grandfather paid cash for 68 years ago. She didn't know my name was on every recorded title in that drawer at the courthouse. So I didn't yell. I didn't argue. I drove straight to my old law partner's office and started building the file. Where are you watching from? And how would you handle this? My name is Cooper Whitfield, and for most of my career, I sat on the quiet side of real estate. I was a title attorney in a small firm in Johnson City, Tennessee. 40 years of reading deeds, tracking liens, and walking nervous buyers through closings. I knew the rhythm of property law the way some men know baseball stats. My wife Eliza used to tease me about it. She'd say I could read a chain of title faster than she could read a recipe, and she meant it as a compliment. Eliza died on a Tuesday in October, 4 years before this story starts. Pancreatic cancer. 8 months from diagnosis to the chair by the window, where she liked to watch the dogwoods turn. After she was gone, I didn't have the heart to drive up to my grandfather's old place on Watauga Lake. We had spent every 4th of July there since our daughter Hannah was 5. I told myself I'd go back when I was ready. 2 years passed. Hannah went off to law school. The lake just sat there in my head. A place I couldn't bring myself to visit. My grandfather was a man named Reuben Whitfield. He bought 47 acres on the North Shore in 1958 with cash from a tobacco crop and a small inheritance. He recorded the deed himself at the Carter County Courthouse the same week, built a cedar workshop, a one-room cabin, and a dock he could fix in his sleep. He died in 1996 and left the whole parcel to my father. My father left it to me. I knew every survey line, every spring, every white oak on that property like I knew the freckles on Eliza's shoulder. So when Hannah called one Saturday morning and said her friend's family had just bought a lakefront cabin in Heron Cove Estates near our property, I felt something twist in my chest. I drove up the next morning. That's when I saw it. 14 cabins, cedar siding, stone chimneys, concrete pads still curing in the sun. They sat in 2 clean rows along the cove, each tagged with a brass plaque reading Heron Cove Estates, Phase 2, Lakefront Series. The model unit had a wraparound porch and a flagpole. A real estate agent in a navy blazer was leading 2 retirees through the front door. There were balloons on the gate. Standing at the head of all of it, holding a clipboard like a foreman, was a heavy-set woman in a white linen blazer and black yoga pants. Blonde hair pulled back into a tight knot, sunglasses on top of her head. She was barking orders at a bobcat operator and pointing at my grandfather's workshop. I parked beside the gravel pull-off and got out slowly. The morning smelled like fresh poured concrete and pine. The bobcat's bucket was already biting into the workshop wall. Cedar splinters fell into the dirt like snow. I felt every one of them in my chest. She turned and saw me, smiled the way a hostess smiles when an uninvited guest shows up. "Sir, this is a private community. You'll need to leave." "This is my land," I said, quiet as I could manage. She laughed. Then she introduced herself. "I'm Brenda Calloway, president of the Heron Cove HOA. We surveyed this entire parcel in 2019 as part of our common area expansion. If you have a problem with that, you can take it up with the courthouse, but I'd suggest you turn around before I call the sheriff." She didn't ask my name. She didn't ask for paperwork. She didn't even look at me twice, and that was her first mistake. I drove home that morning with cedar splinters still on my boots. By Sunday night, I had pulled out my grandfather's deed book, a worn leather binder that had sat on the top shelf of my closet since the funeral. Inside were every original recorded document for the 47 acres. The 1958 warranty deed, a 1973 boundary correction, a 1989 conservation notation, a 2019 routine renewal stamped by the county clerk. I sat at my kitchen table until 2 in the morning, matching my parcel against Brenda's, Common Area Expansion plat. She wasn't off by a few feet. She had claimed 31 of my 47 acres outright. Monday morning, I made certified copies of every recorded instrument and drove back up to the lake. The construction noise had doubled. A new crew was framing roof trusses on cabin 12. The model home had 2 more couples touring it. I parked at the gate and walked toward the marketing trailer, where Brenda was holding court with a young woman in a polka dot dress. "I have proof of ownership," I said, setting the folder on her desk. 47 recorded acres. Continuous chain of title since 1958. The land you've been building on isn't yours. She didn't look at the folder. She looked at me like I was a salesman she'd already turned away once. "Sir, I told you yesterday. Our 2019 survey reclassified that parcel as undeveloped common space. We're well within our rights." "A survey doesn't override a recorded deed," I said. "You can't reclassify land you don't own." She smiled that hostess smile again. I'm sorry, what was your name?" "Cooper Whitfield." "Mr. Whitfield, our attorney has reviewed all the boundary work. If you want to contest it, you're welcome to file with the Chancery Court. But I'd warn you, we have several judges in this county who happen to live in our community, so good luck with that." That sentence sat in the room like a piece of dropped glass. The young woman in the polka dot dress glanced at me, then at her shoes. I asked her, "Are you a buyer?" Brenda cut in before she could answer. "Mr. Whitfield, you are interfering with a private business transaction. I'm calling the sheriff." She picked up the phone. The young woman gathered her purse and left. I stood there a moment longer, watching Brenda dial. Through the trailer window, I could see the Bobcat operator easing my grandfather's workshop into a pile of broken cedar. The sheriff arrived 20 minutes later in a tan Ford Explorer. His name was Deputy Carl Pickering, and I'd known him casually for 6 years. He stepped out, hooked his thumbs in his belt, and said, "Cooper, what's going on?" I told him. I showed him the deed. He read it. His mouth tightened. Brenda walked up before he could speak. "Carl, this gentleman is harassing our development. We have a survey on file. He's trespassing." Pickering glanced at her, then at me. "Brenda, I'm not going to arrest a man who's standing on land that's recorded in his name, but I am going to ask Cooper to step off until we sort this out. Cooper, you'll need to do this through the courthouse, not the trailer." I nodded. "Understood, Deputy." As I walked back to my truck, Brenda called after me, loud enough for the buyers to hear. "Mr. Whitfield, if I see you on this property again, I'll have you arrested. We don't allow disruptive squatters at Heron Cove." A husband and wife glanced up from the porch of cabin 9. The man looked confused. The woman looked embarrassed. Brenda waved at them like nothing had happened. I drove off the lake and straight to my old law partner's office in Elizabethton. His name was Walt Gentry, 68 years old, foreclosure attorney. Semi-retired, but still angrier than most men half his age. I laid the deed and the construction photos on his desk. He looked at me over his bifocals. "Cooper," he said, "she has no idea what she's done." Walt and I spent the next 48 hours building a paper fortress. He pulled the entire HOA filing record from the Secretary of State. He pulled Heron Cove's last 3 years of meeting minutes through Tennessee's open record statute. He pulled every plat amendment Brenda had filed with the Planning Commission. By Wednesday evening, we had a stack of documents 3 inches thick and a clearer picture of the Callaway family business than they would have liked. Brenda's husband, Trent Callaway, sat on the Carter County Planning Commission. He was the man who had quietly approved the 2019 boundary reclassification without sending notice to the recorded property owner, me. Conflict of interest written in red ink across every page. Thursday morning, I filed a formal complaint with the county recorder. Walt filed a parallel notice of adverse claim with the Chancery Court. We attached the original 1958 deed, the 1989 conservation notation, the 2019 renewal, and 3 sworn neighbor affidavits confirming my family's continuous use of the land. 43 pages of documentation, hand-stamped, recorded, and entered into the public record before lunch. By Friday afternoon, Trent Callaway returned the volley. A process server arrived at my front door with a sealed envelope. Inside was a fast-tracked petition to quiet title, filed by Heron Cove Estates against me personally. The The petition claimed my 1958 deed contained fatal title defects because of an old typo in the legal description. A single transposed digit on one of the auxiliary meets and bounds calls, the kind of clerical error that gets fixed every day with a corrective deed. Attached to the petition was a cease and desist letter signed by Trent Calloway as planning commissioner, ordering me to stay off HOA development property or face civil penalties. It was a smart move, filed by a man who knew enough about real estate to be dangerous and not enough to know better. Walt read the petition twice. Then he laughed. Cooper, a quiet title action requires the petitioner to establish their own clean ownership first. They've just put themselves on record as the claimants, which means everything they say about that property is now sworn testimony. They've given us their entire case under oath. That night I drove to the courthouse and pulled the 2019 boundary amendment file myself. I wanted to see Trent's signature. I wanted to see the date. I wanted to see if anyone else had reviewed it. 3 names were on the form: Trent's, a surveyor named Kyle Mott, and a notary stamp belonging to a woman named Pam Ostendorf, Brenda's sister-in-law. A boundary reclassification of 31 acres, signed by a planning commissioner, sealed by his wife's family member, with no public notice and no recorded buyer signature. Tennessee state law required all 3. They had skipped all 3. I made copies of the file. I made copies of Pam's notary commission. I made copies of her marriage certificate, which I pulled from public records the next morning. I started building a separate folder labeled Fraudulent Conveyance Evidence. Saturday morning, the local paper ran a story. The headline read, "Local Title Dispute Threatens Heron Cove's Lakefront Phase 2. Brenda was quoted in 3 different paragraphs. She called me a vindictive widower who had abandoned the property for years and was now trying to extort a settlement from a legitimate community. The reporter, a young man named Garrett Buford, did not call me for comment. I sat at my kitchen table, reading the article with my coffee getting cold. The wind off the ridge rattled the porch screen. I thought about my grandfather sanding cedar in his workshop in 1962. I thought about Eliza laughing on our dock the first summer we were married. I thought about Hannah asking, on the phone, if I was okay. I called the paper, asked for Garrett Buford, told him I had documentary evidence the article was false, and that he had run with one source on a story about real estate law without checking the recorded record. I offered him an interview the following week, with documents. He hesitated, then said yes. I hung up the phone, took a slow breath, and made another pot of coffee. I had a long week ahead. Brenda found out about the planned interview on Monday morning. I don't know who told her. I suspect it was the reporter himself, hedging his bets. By Monday afternoon, she had the HOA board issue an emergency bulletin to all 247-member households, claiming I was a land predator, trying to weaponize old paperwork to seize residents' homes. The bulletin went out by email, by paper notice, and on the community Facebook page. Within 24 hours, half the lake was convinced I was the villain in this story. 2 of the buyers I had seen at the marketing trailer drove past my house slowly that evening. One of them parked across the street for 10 minutes before driving off. I sat at my kitchen window with the lights off and watched. Tuesday afternoon, 3 deputies showed up at my front gate. Different uniforms than Pickering. Hamblin County Sheriff's deputies, not Carter County. Brenda had quietly forum shopped her complaint to a neighboring jurisdiction where she had a cousin in dispatch. The lead deputy, a humorless man named Schutz, handed me a temporary trespass order issued out of Hamblin County District Court that morning. The order forbade me from setting foot on any portion of Heron Cove Estates, pending a full hearing in 6 weeks. 6 weeks. The same week the cabins were scheduled to close. Walt was on the phone in 20 minutes. He explained, in slow, patient sentences, that a trespass order issued by a court with no jurisdiction over the property was not enforceable, but contesting it would cost time we didn't have. He told me to stand down, to not go near the property, to let them think I was beaten. I didn't go near the property for the next 2 weeks, but I did go to the Carter County Courthouse every single morning at 8:15. I sat at a cubicle in the records room with a paralegal named Sue May Ferris, and we walked backward through every transaction Heron Cove had filed since 2017. Every plat, every easement, every common area amendment, every construction loan, every title insurance binder. Sue was 61 years old, wore reading glasses on a beaded chain, and had worked the records room for 28 years. She drank weak coffee from a pink thermos and could spot a forged signature from across the room. On day 3, she set down her glasses, looked at me, and said, "Cooper, somebody's been signing documents in this office that shouldn't have been signed." I asked her to keep going. By the end of the second week, we had identified 17 separate filings where Trent Calloway had used his planning commissioner authority to bypass the recorded property owner. 3 of them involved my parcel. 14 of them involved other parcels in the county: small farms, a church camp, a Civil War cemetery, all conveniently located near Heron Cove's long-term expansion plans. Brenda Calloway wasn't running an HOA. She was running a real estate appropriation operation, and she had the planning commissioner sleeping next to her every night. I called my daughter Hannah that Thursday, told her what we had found. She was quiet for a long time, then said, "Dad, you have to do this carefully. If you go public too early, they'll just delay and bury you in motions until the closings happen and the cabins are sold to innocent buyers." She was right. The buyers were the problem. 11 of the 14 had already signed earnest money contracts. They were good people. 2 were retired school teachers from Knoxville. 1 was a Marine veteran from Asheville. They had no idea they were signing for land that didn't belong to the HOA. I needed to time everything to fall after the closings, not before. Walt and I drew up the plan that Friday night in his office, 2 glasses of bourbon and a yellow legal pad between us. 14 separate foreclosure complaints, 1 TRO request, 1 TBI referral for the Planning Commission fraud. All filed simultaneously, all served on the same Monday morning, the morning after the closing celebration. I didn't say anything for a while. I was thinking about Eliza. Walt watched me. He said, "She'd be proud, you know." I nodded once. Then I picked up the pen and started writing. The discovery that changed everything came on a Saturday afternoon in Sue May's records room. We were halfway through reconstructing the chain of title on my grandfather's parcel when she pulled out a thin yellow folder labeled, in pencil, Whitfield, 1958 vendor lien. I had never seen it before. She slid it across the table. Inside were 3 documents: the original 1958 warranty deed I already had, a purchase money mortgage attached to that deed, executed by my grandfather to the seller, a man named Ezekiel Pruitt, securing $5,000 over 20 years, and a 1989 notice of continuing interest, filed by my grandfather 2 months before he died, preserving the lien rights for 30 additional years. The lien had never been released. I read it 3 times. My hands were shaking. Tennessee real estate law is unforgiving on one specific point. A recorded vendor's lien stays attached to the property until a recorded release is filed. No release, no clear title. Ever. My grandfather had paid Ezekiel Pruitt off in 1978, but Ezekiel had died in 1981 without filing the release. The lien had simply continued, recorded and unreleased, for 47 years. In 1989, my grandfather had filed the notice of continuing interest as a precaution. That notice had a 30-year statutory life. It had been due to expire in 2019. And in 2019, a routine clerk at the courthouse, a young man working his second week on the job, had stamped the renewal as part of a batch processing of expiring notices. The county had no idea what they were renewing. My grandfather hadn't been alive in 23 years. But the renewal was valid. The lien was valid. The notice of continuing interest was valid. And the beneficial interest in that lien had passed by intestate succession to my father, and from my father to me. I held a senior recorded encumbrance on my own land. That alone was extraordinary. But Sue May wasn't done. She handed me a second folder, the HOA's construction loan documents, $6,200,000, borrowed in 2022 to finance Phase 2. The lender was a regional bank in Knoxville. The loan was secured by a mortgage on the development parcel, supported by a title insurance binder issued by a national underwriter. Title insurance binders cover the lender against unknown recorded interests. They do not cover known recorded interests. The 1958 vendor lien was on the public record. The 1989 notice was on the public record. The 2019 renewal was on the public record. The HOA's title company had either missed it or known about it and gambled. When the cabins closed, each individual buyer would receive a deed warranted by the HOA. Each buyer's title insurance would discover the senior lien. Each policy would deny coverage for that specific exception. And the HOA, having warranted clean title, would be on the hook for breach of warranty 14 times over. But the cleanest piece of law was this. Under Tennessee fixture doctrine, when improvements are built on land subject to a senior recorded encumbrance, those improvements attach to the underlying interest. Every cabin Brenda had built was now legally attached to my grandfather's lien. I held the senior position. The HOA held a junior interest in their own development. The buyers, if they closed, would hold an interest junior to both. If I foreclosed, every cabin came with the foreclosure. I sat in the records room until almost 6 o'clock. The fluorescent light buzzed overhead. Sue May went home. The janitor came through with a mop. I stayed at the table, looking at 3 pieces of paper that had been quietly waiting in a county courthouse for 68 years. Then I drove to Walt's office. I laid the folder on his desk. He read for 10 minutes without speaking. When he looked up, his eyes were wet. "Cooper," he said, "we are going to put on a closing day they will never forget." We had 4 weeks before closings, 4 weeks to prepare 14 separate foreclosure complaints, 1 TRO request, a fraudulent conveyance referral to the Tennessee Bureau of Investigation, and a coordinated paper strike that would have to land all at once. If we filed too early, the HOA would delay closings, and the buyers would walk away unharmed. If we filed too late, the cabins would already be transferred, and the legal cleanup would take 3 years instead of 3 days. Timing was everything. Walt brought in 2 associates from his firm, a young woman named Tessa Harlow and a paralegal named Wyatt Crandall, who had spent 7 years in foreclosure law before going part-time. The 4 of us turned Walt's conference room into a war room. Whiteboards, color-coded files, 14 tabbed binders, 1 per cabin, each containing the buyer's name, the closing schedule, the lot description, the construction loan reference, and the lien attachment math. Sue May quietly pulled the historical chain of title on every adjacent parcel. She found 3 small tax sale certificates that were about to lapse, pieces of land that had been delinquent for over a year, sitting at the courthouse waiting for a redemption that wasn't coming. I bought all 3 for under $9,000 total, not because I needed the land, but because I wanted continuous physical control over every access point to the cove. If Brenda tried to claim adverse possession or prescriptive easement at any future hearing, my redemption certificates would close that door before she got to it. In Tennessee, a tax sale certificate purchased before redemption gives you a recorded equitable interest. Recorded means visible. Visible means defensible. Walt also reached out to a colleague at the Tennessee Bureau of Investigation. Her name was Special Agent Loretta Fenwick, and she had spent 15 years working public corruption cases in East Tennessee. He laid out the Planning Commission paperwork, Trent's signatures, Pam's notary, the 17 flagged filings. Loretta listened, asked for copies, took them home and read them over a weekend. On Monday, she called Walt back and said, "We're opening a file." She asked us not to file anything publicly until her office had a chance to interview Pam. 3 days later, Pam Ostendorf walked into the TBI's regional office and sat for a recorded interview. She gave them everything. Trent had pressured her to notarize documents she hadn't witnessed. He had told her it was a routine favor for family business. She had a notebook in her purse where she had logged every signature, because something about the requests had felt wrong from the start. The notebook went into evidence. The TBI now had a cooperating witness inside the conspiracy. Meanwhile, I quietly drove the perimeter of my 47 acres at dawn 3 different mornings. I mounted 4 trail cameras on white oak trunks, angled them at the construction site, the sales trailer, and the road to the cove. I tested the cellular uplinks. I made sure every camera time-stamped its footage. An old farmer named Ezra Holcomb, who had lived next to my grandfather since 1971, drove over one afternoon to bring me a mason jar of his wife's pickled okra. He sat on my porch and told me he remembered the day my grandfather paid Ezekiel Pruitt off. He remembered Ezekiel's wake. He offered to write a sworn affidavit. I accepted. Edna Pruitt, Ezekiel's granddaughter, now 64 and living in Knoxville, was harder to find. Sue May tracked her down through a county welfare cross-reference. Edna remembered her grandfather's papers. She had a metal lockbox in her attic. Inside the lockbox was a handwritten receipt from my grandfather, dated September 1978, marked "Paid in Full," and signed by Ezekiel. She mailed it to me in a padded envelope. I cried when I opened it. By the third week, our binders were complete. The TRO was drafted. The TBI had a sealed indictment ready for Trent. The 14 foreclosure complaints sat in Tessa's desk drawer in a single accordion folder. We had everything we needed. We just needed Brenda to throw her party. The week before closing, Brenda made her last public push. She knew something was wrong. She didn't know what, but she could feel it, the way a coyote feels a thunderstorm coming. So she did what people like her always do under pressure. She doubled the volume. On Monday, she sent a community-wide email titled "Final Update on the Whitfield Squatter Matter." The email claimed I had withdrawn all legal challenges and that closings were proceeding as scheduled and unencumbered. She attached a photograph of my grandfather's workshop, reduced to a pile of mulch. The caption read, "New Phase 2 shoreline access cleared as planned." I read the email twice. I did not respond. On Tuesday, Brenda convinced the local paper to run a follow-up piece. The reporter, Garrett Buford, had not called me for the promised interview. The headline read, "Heron Cove resolves title dispute ahead of Lakefront Phase 2 launch." The article quoted Brenda 4 times and Trent twice. It quoted no one else. I called Garrett Buford. He let it go to voicemail. I left a calm message saying I had documentary evidence the article was false, and that I expected a correction within 7 days. I sent him the same message in writing by registered mail. I kept the green return receipt card. On Wednesday, things got uglier. Brenda asked the Carter County Sheriff to post a deputy at the entrance road to my parcel. The story she gave was that I had made threats toward her family. The sheriff she approached was the same man who had escorted me off the trailer 2 months earlier, Deputy Carl Pickering. Pickering pushed back, said he wasn't posting a deputy on a public road over a private dispute without a court order. Brenda went over his head to the chief deputy. The chief deputy said the same thing. So she paid a private security firm out of pocket. By Wednesday evening, 2 men in black tactical vests stood at the gate to the cove with handheld radios and an SUV with amber lights. They turned away a delivery truck bringing me lumber for a job I was finishing. I called the company. They sent a manager out who personally apologized. He told me the security men had no legal authority. He delivered the lumber the next morning anyway. On Thursday, Brenda crossed the line that ended her. I drove up to the dirt road that ran behind my parcel, a road my family had used for 68 years to reach the small clearing where my grandparents and great-grandparents are buried. 3 white headstones, a rusted iron fence, a black walnut tree my grandfather planted in 1972. When I got to the clearing, there was a chain-link fence around the burial plot, 8 feet tall, topped with razor wire, padlocked. A bright orange placard zip-tied to the gate read, "Restricted Area, Heron Cove Estates Common Property, Unmarked Burial Site Pending Review." My grandfather's grave, my grandmother's grave, my great-grandmother's grave, behind chain link. I stood there for a long time. The wind moved through the walnut leaves. Somewhere down the cove, a hammer rang against a roof. I didn't break the lock. I didn't kick the fence. I didn't yell. I walked back to my truck and got my camera out of the glove box. I photographed every angle. I photographed the placard. I photographed the lock and the manufacturer's stamp on it. I photographed the tire tracks where her crew had driven their truck over my grandfather's footpath. Then I drove to Walt's office and laid the camera on his desk. Walt looked at the photos one by one. His face didn't change for the first 6. On the 7th, his jaw tightened. "This isn't a property dispute anymore," he said quietly. "She just gave us a desecration claim under Tennessee Code, 39-17-311. That's a Class E felony. Special Agent Fenwick is going to want this in the indictment." I nodded. He set down the camera. "Cooper, you understand what this means?" "I do." Brenda just put herself in handcuffs at her own party. I didn't say anything. I was thinking about my grandfather's hands. Friday was silent. Brenda thought she had won. She did not call. Trent did not call. The security men were gone from the gate by Friday morning. The sales trailer's lights stayed on late into the night as her team prepared the closing day program. I spent Friday at home making copies. Tessa drove down from Walt's office with a portable scanner, and we duplicated every binder, every exhibit, every piece of correspondence. 3 sets, one for the Chancery Court, one for the TBI, one for me. By 8 in the evening, my dining room table was covered in neat stacks bound with blue rubber bands. Hannah drove in from Nashville at 9. She had finished her last final exam Wednesday. She walked into the kitchen, dropped her duffel by the door, and hugged me without saying anything for a full minute. She was 24 years old, and she smelled like the same coconut shampoo Eliza used to keep on the bathroom shelf. She made coffee. Walt arrived at 10 with Tessa and Wyatt. The 4 of us sat at the table while Hannah spread the binders out and walked through every filing one more time, the way her mother used to walk through Christmas dinner prep. She caught 2 minor errors in our service of process list. Walt amended them on the spot. "Dad," she said, "are you ready?" "I am." She looked at the photos of the chain-link fence around the family graves for a long time. Then she set them down and said, "Mom would want her name on something good after this." I told her I'd been thinking the same thing. Walt walked us through the timing. The closing was scheduled for 2 o'clock Saturday afternoon at the Marina Pavilion. Champagne reception, ribbon cutting, 14 scheduled signings. Local news crews from Channel 11 and Channel 14 had been invited. Brenda had sent a press release that morning with the subject line, "A Lakefront Legacy Begins." Walt had a copy in his folder. He'd highlighted 3 paragraphs that would matter at trial. We were going to wait until 12:45. By that time, the buyers would be checked in and seated. The press would be set up. Brenda would be at the podium, reviewing her notes. Trent would be near the front, glad-handing investors. At 12:45, Walt would walk in with a bailiff, carrying a sealed envelope from the Carter County Chancery Court, a temporary restraining order halting the closings and freezing all earnest money. At 12:50, Special Agent Fenwick would walk in with a TBI arrest warrant for Trent on charges of fraudulent conveyance and tampering with public records. At 12:55, Tessa would distribute 14 individual notices of intent to foreclose to each buyer. At 1 o'clock, I would step to the microphone. "You don't have to," Walt said. "We can handle the entire delivery. You don't need to put yourself out there." "I want to," I said. "Those buyers deserve to hear it from me. So do those reporters. So does she." Hannah reached over and squeezed my hand. Saturday morning came clear and cold, frost on the windshield. A blue jay arguing with a squirrel in the maple by the driveway. I made coffee at 6. I ironed a charcoal suit Eliza had picked out for me at a Nashville store the spring before her diagnosis. I shaved. I trimmed my hair. I put on the suit and looked at myself in the bathroom mirror and tried to recognize the man looking back. He looked tired, but he looked ready. Hannah made eggs. Walt called at 9 to confirm Fenwick was in position. I drove the long way to the lake, past the ridge road my grandfather used to take to deliver tobacco to the Elizabethan Co-op in 1962, past the old Pruitt place where Ezekiel had signed the receipt I now had photocopied in my breast pocket, past the cemetery where Eliza was buried under a small granite marker with dogwood blossoms etched at the corners. I stopped at the cemetery for 10 minutes. I told her where I was going. I told her what we were doing. I told her about Hannah's idea for the trust fund. I told her about the chain-link fence around the family graves and how we were going to take it down before sundown. Then I got back in the truck and drove to Heron Cove. It was 11:45. The Marina Pavilion at Heron Cove had been converted into a glass-walled event hall with white tablecloths, lake views, and a cedar arch wrapped in white roses. 14 oak desks were arranged in a horseshoe along the back wall, each one labeled with a buyer's name in calligraphy. A string quartet played by the windows. A buffet of shrimp cocktail and cheese boards lined the side. Sparkling cider in fluted glasses. The smell of fresh roses and lake water and lemon polish. I parked at the far end of the lot beside a Channel 14 news van. Hannah parked beside me. We walked in together at 11:55 and sat in the back row of folding chairs reserved for community guests. Brenda was at the podium, adjusting a stack of index cards. She didn't see me at first. When she did, Her face froze for half a second. Then she smiled the hostess smile and went back to her cards. She thought I had come to watch her win. The program started at 12:15. Brenda welcomed the buyers. She introduced Trent. She introduced the sales agent, the marketing director, and a county commissioner whose campaign Trent had funded. She talked about vision and stewardship and the future of the lake. The reporters nodded politely. The buyers smiled. One of the retired school teachers I had seen at the trailer sat at desk number 9 with her husband, holding her purse in her lap. At 12:43, the door opened. Walt walked in first. Behind him came a uniformed bailiff carrying a sealed manila envelope. They crossed the room without hurry, all the way to the podium. Brenda stopped mid-sentence. The bailiff said, in a clear courtroom voice, "Ma'am, I have an order from the Chancery Court of Carter County." Brenda took the envelope. Her hands were not steady. She broke the seal and read the first page. The pavilion went very quiet. The string quartet stopped playing. The Channel 14 cameraman zoomed in. The order was a temporary restraining order, halting all transactions on the listed parcels and freezing all earnest money accounts pending a full hearing. 14 parcels. By legal description. Brenda looked up at Walt. "What is this?" "That is your notice that 14 separate foreclosure actions have been filed this morning against the parcels you are about to convey," Walt said. "Each buyer at this event will receive their personal copy in approximately 3 minutes." Tessa walked in behind him with the accordion folder. She began handing 14 individually labeled envelopes to 14 buyers. The retired school teacher opened hers, and her face went pale. Her husband stood up. The doors opened again at 12:51. Special Agent Loretta Fenwick walked in with 2 TBI agents and a Carter County deputy. She walked straight to Trent Calloway at the front row. "Mr. Calloway, I have a warrant for your arrest on charges of fraudulent conveyance, tampering with public records, and notarial fraud. Please stand up and place your hands behind your back." Trent stood. He looked at Brenda. Brenda did not look at him. The cuffs clicked. The Channel 11 reporter began typing into her phone. The Channel 14 cameraman swung his camera toward the front of the room. 2 buyers were already on their phones with their attorneys. The retired school teacher's husband walked to the podium and asked, quietly, if anyone could explain to him what had just happened. I stood up. Hannah squeezed my hand once. I walked to the podium. Brenda stepped back. I placed my grandfather's deed binder on the lectern beside the bouquet of white roses. I tapped the microphone twice to make sure it was hot. "My name is Cooper Whitfield," I said. "My grandfather, Reuben Whitfield, paid $5,000 cash for the 47 acres you are standing on in 1958. He recorded that deed at the Carter County Courthouse the same week. Neither he, nor my father, nor I ever sold a single foot of this land. I hold a senior recorded vendor's lien, renewed in 2019, on every parcel currently being conveyed. As of this morning, every cabin on this property is in foreclosure. Every closing scheduled for this afternoon is void." I paused. I looked at the school teacher. I looked at the Marine veteran. I looked at the 11 other buyers. "You did not buy what you were told you bought," I said. "But I am not your enemy. We are going to make this right." Brenda made a sound. It might have been a word. It didn't matter. I stepped away from the microphone. The next 90 days unfolded slower than that one Saturday afternoon, but every day moved in one direction. The TRO held. The Chancery Court consolidated all 14 foreclosure actions into a single proceeding. The TBI's case against Trent grew teeth as Pam Ostendorf's notebook traveled from 1 charge to 7. Brenda was indicted 3 weeks later for desecration of human remains, conspiracy to commit fraud, and breach of fiduciary duty as an HOA officer. The Heron Cove HOA held an emergency meeting on a Tuesday night in May. 247 member households attended. Brenda Calloway was removed from the presidency by a vote of 221 to 26. Her 2 closest board allies were removed by similar margins. Within a month, Brenda and Trent had listed their house on the lake and moved to Charleston, where the Planning Commission was not waiting for them. They have not been back. The 14 cabins were not destroyed. That was the choice that surprised people most. I did not foreclose to take the homes. I foreclosed to take control of the title so I could fix it. Walt and I worked with each buyer individually. The HOA's own assets, the marina, the clubhouse, the pavilion, were liquidated under court order, and the proceeds funded clean transfers of clear title to every legitimate buyer, at no additional cost. 2 buyers walked away with full refunds. 12 closed on their cabins 6 weeks later, this time with a deed that actually meant something. The retired school teacher hugged me at her closing and cried into my shoulder. Her husband shook my hand and didn't say anything because he didn't have to. The construction loan bank settled with the title insurer. The insurer settled with the HOA receivership. None of those losses ever touched the buyers. In July, we filed papers to create the Whitfield Lakefront Land Trust. 30 acres of my grandfather's parcel, including the cove, the burial plot, and the original cedar woodshop site, were donated permanently to a conservation easement with public shoreline access. Hannah named the trust the Eliza Whitfield Lakeshore Preserve. The dedication ceremony in September drew almost 400 people. Ezra Holcomb cut the ribbon. Sue Mae Ferris and Edna Pruitt sat in the front row. We rebuilt the workshop. Same cedar, same dimensions, same shape my grandfather sketched on a piece of butcher paper in 1958. I teach a free woodworking class there every other Saturday for kids in foster care. Hannah comes home most weekends to help and to keep me from falling behind on paperwork. We opened the Whitfield Title Help Clinic in October out of a small storefront in downtown Elizabethton. Free legal advice for rural landowners facing title disputes, encroachment claims, and HOA overreach. Walt volunteers 2 afternoons a week. Tessa runs the intake desk. The chain-link fence around the family graves came down on a Sunday afternoon in June. Hannah and I cut the lock with bolt cutters from my truck toolbox. We rolled the fencing up and hauled it to the recycling yard the next morning. The black walnut tree my grandfather planted in 1972 is still there. It dropped a heavy crop of nuts in October. I gathered some in a basket and took them to the cemetery and put them on Eliza's grave. I think about my grandfather often, about the patience he had, about the way he wrote dates on every receipt in fountain pen ink, about the small, quiet, ordinary acts of carefully recording what was true, so that one day, decades later, the truth would still be standing when somebody finally needed it.
There's something about Cooper Whitfield's story that gets me every single time. It isn't the size of the win. It isn't even the courtroom moment. It's the patience. 40 years of quiet record keeping done by his grandfather in fountain pen ink ended up being stronger than the planning commissioner, an HOA president, and a $6 million construction loan combined. That's the real lesson. Petty power burns loud and fast. Brenda Calloway thought she could shout her way into ownership of land she had never paid for. She forgot that paper survives shouting. Cooper's strength wasn't anger, it was preparation, documentation, and 40 years of knowing the rules better than anyone trying to break them. In the end, those 14 families got the home they paid for. The lake got 30 acres of permanent public access, and a small workshop got rebuilt in Cedar exactly the way Rebuild Whitfield drew it in 1958. If you've ever been steamrolled by someone who confused volume with authority, drop your story in the comments. I read every single one. Hit subscribe to stay with us. And next week, a developer who bulldozed a neighbor's barn at 5 in the morning. At 5 in the morning, and what that neighbor had buried underneath it.